Hello, everybody. I don't know if we're going to get too much of a visit out of our sweet, sleepy little girl because she got spayed today, and so she's resting. Hey, how you doing down there, Earl? You having fun tearing that up? Yeah, I thought so. Oh, it's okay, baby. You don't have to get down. You don't have to get down, love. Everybody knows you're here, and they know that you're droozy. Hello, Nana Laura. Hello, C-Rex. Yay! Hello, Eileen E. Carlin. Oh, hi, baby. Hello, Chinny. Hello, Patrick B. Hello, Linda Applegate, my love. Oh, I got one of those, Modari or something like that. They're these giant round, it holds a round scratching pad, but then it's got like a trench all the way around it, and you can put a ball in there and use it like one of those toys, or I put a little bit of kibble around the outside of the perimeter, and then Tiny Kitten and Earl, they'll reach in with their paw and they'll pull out one piece at a time. It's super cute. So I kind of use it like a little slow feeder. But yeah, he likes to tear up the middle, which is fine. That's what it's intended for. Hello, Salty Buddha. How's my absolutely amazing stranger doing? Haven't seen you for so long, and I've missed you. Hello, Catherine Gaston. Yay! What a wonderful day for a celebration. Oh, wow. You got this. You got this. And Eva's got eye boogers. Yeah. She was crying, and then I gave her medicine. And then they turned to eye boogers, I guess. My poor baby. Our poor baby. Oh, I love you, Salty Buddha. All right, so I found a judge that I hadn't seen before, and I wanted to run him yesterday, but it's been really busy with my daughter home, and I take her back home tomorrow. So I've been trying to squeeze as much time with her in with, doing stuff for the channel, and she kind of took precedence a little bit, just a little bit. So I don't get to see her very often. And now, now that she's in college and stuff, it's Mama takes the back burner. But yeah, she's home, so I took advantage of it. But I did find this new to me judge, and I like him. I like him a lot. And he does some good stuff. And oh, by the way, I got my hair cut today. I love it. Just the trim. But my curls should be back now. You'll see it better tomorrow after my shower. I'll shower before I stream. And it'll look much better than it does even right now. All right, let's get into it with the new judge.
Person at the jail, what is your name?
Frank Williams.
Mr. Williams, do you have a mailing address?
Oh, yes, I do. It's 842 North Simons, Cadillac, Michigan.
Is that 1M or 2?
It's only 1M.
And that's street, correct?
Yes.
Do you have a good phone number?
I don't. I just got a new phone. I'm not really sure what the number is.
Do you have an email address?
I do not.
Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, I did.
I have a complaint that alleges that on or about March 26, 2025, here in the city of Cadillac in Wexford County, you did in count number 1, breaking and entering illegal entry without owner's permission. That is a 90-day misdemeanor and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, I do.
Did you read and sign an advice of rights form at the jail, talk about your rights to an attorney and your rights to a trial?
Yes.
Do you have any questions for me about those rights?
No.
Did you understand those rights?
Yes, I did.
You have the right to be represented by an attorney. If you can't afford an attorney, one will be appointed to you at public expense, but you may be required to repay a portion of that expense. You also have the right to represent yourself. Do you plan to hire an attorney today?
I did.
Do you have the financial means to hire an attorney?
No.
So do you wish the appointment of an attorney? You could release that attorney if you.
No, I take that back. No, I don't want an attorney.
Want to represent yourself?
Yes. I apologize.
So no need to apologize. We just have to go through a process. So bear with me for just a second.
Okay.
I have a form that I need to go through with you if you're going to represent yourself, and I'll read that form to you. It says, I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime, and I have read or have had read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and that the court will appoint one for me at public expense if I cannot afford one. That I have the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. How many years of education do you have?
11.
Okay, so we have a high school dropout who has no doubts about his decision to represent himself.
It goes on to state that I have 11 years of education. I read and understand the English language, and I am mentally sound. After having gone through that, you still wish to represent yourself?
Yes.
I'm going to put on here that we discussed this on the record. And I will mark that you are going to represent yourself. The next stage is the entering of a plea. You have the right to enter a not guilty plea, stand mute, or plead guilty. If you stand mute, the court would enter a not guilty plea on your behalf. To the charges that you did break and entering how do you plead?
I plead guilty.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes.
It is your free choice to enter a guilty plea today. If you pled not guilty, we would set the matter for a pretrial conference and give you the opportunity to discuss the matter with the prosecuting attorney to see if there's a way to resolve the case.
I would like to proceed in pleading guilty today.
Okay. Then to the charge that on or about March 26, 2025. Well, let me back up because I forgot something. Has anybody promised you anything in order to get you to plead?
No.
Has anybody threatened in any way to get you to plead?
No, sir.
Is it your own free choice to plead guilty today?
Yes, it is.
Are you currently on probation or parole in any other county?
No, I'm not.
Are you on bond in any other file?
No.
Then to the charge that on or about March 26, 2025, in the city of Cadillac, you did break and entering a building without permission. How do you plead?
Guilty.
I must have you tell me what it is that makes you guilty. So what happened presumably earlier today?
Well, me and my friends, my co-defendants or whatever, you know, they're homeless. I'm homeless, and it's just rough finding a place out there. And well, he told me about this. Ethan told me about this spot that, you know, I could stay for a night because it was cold last night. You know, in the wintering, it doesn't seem like it's breaking. So I went there with him and I entered that building and I got arrested there.
And what type of building was it that you entered?
I think it was a old train station, I think.
And did you have the permission of the owner to do that?
I did not.
And would you agree with me that that was here in the city of Cadillac?
Yes, that was.
Mr. Carnes, do you believe the defendants provided a factual basis to accept the plea and the court's been compliant with the court rules?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Sir, you've been found guilty of breaking and entering illegal entry without the owner's permission, the 90-day misdemeanor and or a $500 fine. Mr. Carnes, do we need to set this over for sentencing? This would be a victim crime, would it not?
Yes, Your Honor.
The court will go ahead and we'll set this matter for sentencing, give the owner of the property the opportunity to address the court in regards to sentencing. Mr. Williams, you do have the opportunity to be released on bond. In your past, I show in 2014 an attempt to resist and obstruct, in 2015 an attempt to resist and obstruct, 2018 a retail fraud third, in 18 a domestic violence, in 20 a disorderly drunk, in 22 a possession of methamphetamine, and obstruction of justice. Mr.
That's not correct. There shouldn't be, on that last one, there shouldn't be an obstruction charge. I never got convicted of that.
Let me take a quick look here. Well, your criminal history shows that you were found guilty in the 55th Circuit Court out of Clare County on 8/1/22, that you were found guilty of obstructing justice. So you might want to check into that if that's not your understanding.
Okay. All right.
Mr. Williams, your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense that you just pled to, and the threat that you pose to the community. Before I get to you, Mr. Carnes, anything regarding bond?
It is troubling that these people are invading this property. I would ask the court for a cash bond.
Mr. Williams, is there anything you'd like me to know regarding setting bond?
Yes, actually, while I've been here, and they did say that was going to be a problem even getting, because I have no funds. Like, and I called my mom, and she said that since if I get out this time, that I could go to a rehab, that she will let me go there until I can get going, so I won't be, I won't be stuck in like, because I'm not out here just breaking into people's houses to steal things or anything like that. I'm not that type of person. It's just, it does get hard, man, and like, well, I mean, there's not nothing to justify this, okay, but that was not my intentions. I didn't have no intention of harming, stealing, anything like that. And if I get released, because I have no money, I can't get bonded out, and I don't think. I was hoping to get a PR bond, and
If I
Yeah,
gave
I
you a
have some-
PR bond, if I gave you a PR bond, where would you go?
Simons, it would be my mother's,
That's your-
my house.
That's still your mother's house? I show that you have 2 failed appears out of the 50th District Court in Pontiac. Were you aware of that?
Yeah, that's so far, man, I couldn't, like I said, didn't have nobody then. I had no way, it was, I can't walk there, but like, I promise you, like, this is something small. Like, this is something small that I did, even though maybe it's not small to the victim. But I promise you that, like, it's a 90-day misdemeanor. Like, I'll show up for it. I'm here in Cadillac.
Well, the court will go ahead. Well, I do find that you pose as a possible flight risk, given that you are homeless and that you've got 2 failed appears. I also know that you have substantial ties to the community. So I'm going to go ahead and issue a PR bond. You are to have no contact with the property at 1 North Street. Do you understand that?
Yes, sir.
You are also to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. If you are found in violation of those terms of probation, you could be held without a warrant, and your bond, I'm sorry, if you're found in violation of those terms of your bond, you could be arrested without a warrant and your bond revoked. Do you understand that?
I understand.
Okay. Before you are released from jail today, you'll receive your next court date. Okay,
Okay.
good luck. Next
Thank you very
arraignment.
much.
Person at the jail, what is your name?
Ethan
What's your
Hill.
last name? Ethan Hill?
Hill. Yes.
This is the people of the state of Michigan versus Ethan Patrick Neil Hill case.
Now, who's with me on this? Who thinks that Ethan is the buddy that told them about these trains that they could go hop into, or this train station? I think this looks like a job Ethan concocted.
Number 251056 SM. We're here for an arraignment. Mr. Hill, do you have a good mailing address?
I don't right now, no.
Do you have a phone number?
No, I don't have a phone number either. I don't have a phone.
Do you have an email address?
No, I don't.
Mr. Hill, did you meet with somebody from the public defender's office today?
Yes, I did.
I have a complaint that alleges that on or about March 26, 2025, here in the city of Cadillac in Wexford County, you did in count number 1, break and entering illegal entry without owner's permission. That is a 90-day misdemeanor and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, and I was also hoping that I could come in contact with whoever it was and apologize thoroughly.
Okay, we have some steps we have to go through, so let me just ask my questions, okay?
Okay.
Do you understand those charges and the potential penalties?
Yes, I do.
Okay. Did you read and sign an advice of rights form there at the jail, talked about your rights to an attorney and your rights to a trial?
Yes.
Did you understand that form?
Yes.
Do you have any questions for me about those rights?
No, I don't.
You have the right to be represented by an attorney. If you can't afford an attorney, one will be appointed to you at public expense, but you may be required to repay a portion of that expense. You also have the right to represent yourself. Do you understand that?
Yes.
Do you plan to hire an attorney today?
No.
You wish the court to make an appointment of an attorney?
Yes.
What is your current source of income?
I don't have any.
Okay, the court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea on your behalf, and will set the matter for a pretrial conference. You also have the right to have a bond set. Your bond is based upon the threat that you pose to the public, the seriousness of the charges, and the likelihood of you appearing at future court appearances. Counsel, I show two deferrals in the defendant's past in 20 and 21. Mr. Harrison, anything regarding bond?
Not really, Your Honor. It's a relatively low level crime that he's alleged to have done here. He had reasoning behind it. Wasn't any malicious intent behind what he did. He is currently homeless. We've discussed how we might work together on how to fix that as well in the future. As far as him returning to court, say he wants to. I don't know where he's gonna go if you release him, but we can always get him some housing somewhere, even if it's just a shelter.
Mr. Carnes?
Thank you, Your Honor. I just asked for a no contact order with the address on this. Sure.
Mr. Hill, if I were to release you from jail, where would you go?
Up to the shelter.
Have you been there before?
Yeah, I've been there before.
Are you welcome there?
It's been about a year since I was up there. I didn't have any problems when I left, so there shouldn't be a problem when I go back up there, you know.
Other than the housing situation and communication system, you not having a phone or a mailing address, if I were to release you, is there anything that would stop you from appearing at court?
No, I'm gonna do what I'm supposed to do, you know. I want to be able to get it over with like a man and stuff, you know. There's not really any reason to run from something that you did wrong, you know. It's just better to fix it, so.
Okay, the court will enter a PR bond. That means you won't have to post any money to get out of jail. I'm going to order the
Okay.
following conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. Additionally, you are to have no contact with the property located at 1 North Street here in the city of Cadillac. Do you understand that?
Yes.
Okay. Any questions?
No.
Okay, thank you. Next arraignment.
Now, I will give these guys this much. They're very polite. I do believe, I mean, there's been documentaries that I've watched on people who choose to live off the grid, basically. You know, they don't keep a phone. They'll use like a parental address instead of, you know, actually living there. But they pretty much just live on the train tracks and in tunnels and under bridges and, you know, live their life. And it kind of sounds like this might be more of a choice to live like this rather than forced circumstances. I don't know, though. I don't have enough of the story to make that judgment.
Person at the jail, what is your name?
Stephen Petravich.
This is the people of the state of Michigan versus Stephen Michael Petravich, case number 251055 SM. We're here for an arraignment. Mr. Petravich, do you have a good mailing address?
7 Spice Lake,
7-6.
Michigan.
Hold on.
Yeah.
You broke up on me. What was the road name? Okay. And you get mail there?
Yes, sir.
Do you have a good phone number?
I just got that phone number, sorry.
Do you have an email address?
.com.
Did you have the opportunity to meet with somebody from the public defender's office today?
I have.
I have a complaint that alleges that on or about March 26, 2025, here in the city of Cadillac in Wexford County, you did in count number 1, breaking and entering illegal entry without the owner's permission. That is a 90-day misdemeanor and or a fine of $500. Do you understand those charges and the potential penalties?
I do, sir.
Did you read and sign an advice of rights form there at the jail, talk about your rights to an attorney and your rights to a trial?
Yes, sir.
Did you understand those rights?
I do.
Do you have any questions for me about those rights?
No, sir.
You have the right to be represented by an attorney. If you can't afford an attorney, one may be appointed to you at public expense, but you may be required to repay a portion of that expense. You also have the right to hire your own attorney. Did you plan to hire an attorney today?
No, sir.
Plan to represent yourself or request the appointment of an attorney?
I request the appointment of attorney.
What's your current source of income?
I don't have a source of income right now. I'm not working, but I do get help from my parents.
The court will enter a not guilty plea, will make a referral to the public defender's office for the appointment of an attorney, and will set the matter for a pretrial conference. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Gentlemen, historically, I show in 2019 an operating while intoxicated, 2020 interfere with electronic communications and aggravated domestic, in 21 a trespass and an attempted resist and obstruct, in 20 a disorderly drunk, 21 attempted malicious destruction of personal property less than $200, and assault and battery, in 22 an attempted resist and obstruct, 22 use of methamphetamine, and 23 possession of methamphetamine. Mr. Harrison, anything regarding bond?
Mr. Petravich has long-standing ties to this community. Acknowledges that he's had a rough go of things, particularly a couple of years ago. As far as I know, he doesn't have any history not showing up at court, and as he acknowledged to you, he does have a stable place to go and people that can keep him organized and appearing in court and that sort of thing.
Mr. Carnes?
Your Honor, I'd ask for a no contact order with the address.
Mr. Petravich, if I were to release you from jail, where would you go?
I'd probably have to go to my mom's tonight.
Is
In
that
Fife Lake.
Fife Lake,
Yes,
that Fife
yes.
Lake address? Is there anything that would stop you from coming to court?
No, sir.
Are you currently on probation?
No.
The court will issue a PR bond. That means you can be released without posting any funds. However, you are going to be subject to the following conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and commit new crimes. Additionally, you are to have no contact with the property located at 1 North Street here in the city of Cadillac. Do you understand that?
I do.
Do you have any questions?
No, sir.
Okay, thank you. That's it.
You have 2 more walk in.
We're done with the jail.
Oh, yes, go ahead, right now.
Thank you, jail.
Do we have a fourth arraignment, Your Honor?
Oh, yes, I'm sorry. Judge Van Alts has that one.
Okay.
John Edwards. Mr. Edwards, this is the people of the state of Michigan versus John D. Edwards, case number 25783 SM. We're here for an arraignment. What's a good mailing address for you?
Pardon?
A good mailing address? Cadillac?
Yeah.
Do you have a good phone number?
878.
How about an email address?
No.
Did you have the opportunity to meet with somebody from the public defender's office today?
No.
Harrison? Sir, if you'd like to go out with Mr. Harrison, he can talk to you. Kevin Vulk? This is case number 25784 SM. We're here for an arraignment. Mr. Vulk, what's a good mailing address for you?
Lake City, Michigan, 49651.
And do you have a good phone number?
989, yes,
How about an email address?
@gmail.com.
You had the opportunity to meet with somebody from the public defender's office.
Yes, Your Honor.
I have a complaint that alleges that on or about July 11th, 2023 in Herring Township here in Wexford County, Michigan, you did commit the offense of malicious destruction of personal property, $200 or more, but less than $1,000. That is a 1-year misdemeanor and or a fine of $2,000 or 3 times the amount of destruction or injury, whichever is greater. Do you understand those charges and the potential penalties?
Yes.
I have a signed advice of rights form. Did you read and sign this form? Talk
Yes.
about your rights to a trial and
Yes.
an attorney. Did you understand that form?
Yes.
Do you have any questions for me about those rights?
No.
You have the right to be represented by an attorney. If you can't afford an attorney, one will be appointed at public expense. You may be required to repay a portion of that expense. You also have the right to represent yourself. Do you plan to hire an attorney today?
Yes.
Do you have the financial means to hire an attorney?
Yes.
The court will enter a not guilty plea. We'll set the matter for a pretrial conference. That's going to be the opportunity for your attorney and the prosecution to see if there's a way to work out the case short of going on the trial track. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, I show in 2020 a larceny less than $100, in 23 an assault and battery, and in 18 a case handled under a deferral statute. Mr. Carnes, anything regarding bond?
Your Honor, I will say the defendant was cooperative with law enforcement during the investigation. In light of that, I think our bond will be appropriate. I do ask for a no contact order with Cassandra Nickerson.
Mr. Vulk, without getting into the facts of the case, is there anything you'd like me to know regarding bond?
No.
Okay.
All I just know is that I have a steady job and I am supposed to have my daughter this weekend. So if I go to jail, I'm missing out on the opportunity to father my child.
Where are you employed?
Rogers of Lake City.
Okay, the court will enter a PR bond. That means you're free to go. You won't have to post any money. However, you are required to appear as ordered to keep your contact information current, not leave the state without permission, and commit no crimes. I'm also going to enter a no contact order with Cassandra Nickerson. No contact means no contact of any kind, not by phone, not by text, not by email, not by social media, no driving by the house. Do you understand that?
Yes.
If you are found in violation of your terms of bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes.
Because of the nature of the offense charged, you are required to get your fingerprints taken. I have signed a fingerprint order. You'll need to pick up a copy of that at the front window. Call the Wexford County Sheriff's Department to make arrangements to have your fingerprints taken.
You want me to do that today?
The sooner the better. Yeah, I can't guarantee they'll get you in today, but you can at least make arrangements to have that done.
Okay.
Okay? If you don't do that, that is a fail to follow court order, and you could face consequences for that.
Okay.
So go back out to the front window where you checked in. You'll get your next court date. Make sure your attorney that you hire is aware of that court date, because until they file an appearance, they won't know about the court date.
Okay.
And then don't forget about your fingerprints. Okay? Thank you. We are back on the record in the people of the state of Michigan versus John D. Edwards, case 25783 SM, continuing our arraignment process. Mr. Edwards, did you have the opportunity to meet with somebody from the public defender's office?
Yes.
I have a complaint that alleges that on or about October 29th, 2024, in Selma Township, Wexford County, you did in count number 1, commit the offense of malicious destruction of personal property, $200 or more, but less than $1,000. That is a 1-year misdemeanor and or a fine of $2,000 or 3 times the amount of destruction or injury. In count number 2, you did commit the offense of larceny, $200 or more, but less than $1,000. That is a 1-year misdemeanor and or a fine of $2,000 or 3 times the value of the property stolen, whichever is greater. Do you understand those charges and the potential penalties?
I don't understand the charges really, but
Well, let me phrase it this way. Do you understand that based on the information the prosecution has, they've authorized those charges? Not that you necessarily agree with them, but that's what you've been charged with.
Yeah.
Okay, and you understand those potential penalties?
Yeah.
Sir, did you read and sign this advice of rights form? Did you have any questions for me about those rights? Did you understand those rights?
Yeah.
You have the right to be represented by an attorney. If you can't afford one, the court would appoint one at public expense, but you may be required to repay a portion of that expense. You also have the right to represent yourself. Do you plan to hire an attorney today?
I can't afford them.
Would you like the court to request the appointment of an attorney?
Yeah.
What is your current source of income?
Retired.
The court will enter a not guilty plea. We'll set the matter for a pretrial conference. That's where the court, or I'm sorry, that's where the attorney and the prosecutor will see if there's a way to resolve the case. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the charged offense, and the threat that you pose to the public. Historically, I show a 1974, a larceny, and 16, a drug house, and possession of marijuana, and an 18, use of a computer to commit a crime. Bailiff, can we grab Mr. Harrison? Mr. Harrison, we're up to the point of bond regarding Mr. Edwards. Is there anything you'd like to say?
Well, this is, sounds like a dispute with his neighbor. He's lived in the same location for as long as he can remember. He's a longstanding member of this community. He's recently retired from active employment. He's not going anywhere. I don't see any reason why he would fail to return to court on this. He's interested in knowing what the basis of the charges are. I think he's a good candidate for PR.
Mr. Carnes?
Your Honor, I'll leave the amount of bonding the court's discretion, but I would ask for no contact orders with Lori and Leitner, as well as the address and all the property at, yep, I can get the township to.
I assume that's Cadillac?
Yes.
The venue listed in the report was Selma Township. I don't know what city that would be.
It's Cadillac ad. Oh,
Well, it appears to be next or pretty close to the
Yeah.
defendant who has a Cadillac address, so.
Yeah, that's true.
John's
Okay,
address.
thank you.
Mr. Edwards, if I were to release you on your own recognizance, is there anything that would prohibit you from coming back to court?
No.
Okay. The court will issue a PR bond. That means you won't have to post any money. You are required to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. In addition, I'm going to order that there be a no contact with the property located at Cadillac or a Lori and Leitner. No contact means no contact of any kind, not by phone, not by text, not by email, letters, driving by the house. Mr. Carnes, anything else?
No, Your Honor, thank you.
Sir, I did forget to mention, this is the type of crime in which the way it's charged, it does require your fingerprints to be taken. I have signed a fingerprint order. You'll need to pick up a copy of the order at the front window where you checked in, contact the Wexford County Sheriff's Department, and make arrangements to have those fingerprints taken. Okay, go back out to the front where you checked in, get a copy of your next court date and a copy of that fingerprint order.
All right. thanks.
Okay, thank you. Okay, court next calls the people of the state of Michigan versus Cheyenne Emery, case number 25140 SM. Time and date set for a pretrial. Appearances, counsel.
Nate Carnes on behalf of the people.
Robert Champion appearing on behalf of Emery, appearing by Zoom.
Ms. Emery, are you able to see and hear us this morning? You're muted on your end.
Yes, sir.
Okay. Mr. Champion, this is a case that had been assigned to Judge Van Alts due to the conflict I had at the time of charging. Is there a waiver of that conflict?
Yes, Your Honor, if we could just do that briefly on the record for my client.
Certainly. Ms. Emery, do you understand that I was the elected prosecutor at the time that the charge arose and at the time that it was charged? And because of that, I inherently have a conflict with the file. You have the option to waive that conflict today, which means that I would be able to act as the judge, or you have the opportunity to not waive that conflict and the judge that it's been assigned to, which is Judge Audrey Van Alst, would continue to hear the case. Have you had the ample opportunity to discuss that with Mr. Champion today?
No.
If I could have just a moment.
You may. I will put you both into a breakout room so you can discuss that.
Thank you.
Mr. Champion, are we ready on Ms. Emery?
Yeah, you're right.
Okay, we are back on the people of the state of Michigan versus Cheyenne Dawn Emery, case number 25140 SM. Ms. Emery, are you still able to see and hear us?
Yes, sir.
We left off so you could talk with Mr. Champion about the conflict that I had. And I've been provided a waiver of disqualification that has, it appears Mr. Champion signed your name with permission. Is that correct?
Correct, sir.
And you're allowing me to then act as the judge on this case?
Correct, Your Honor.
All right. I have signed that disqualification as well, so we will remove this from Judge Van Alt's docket and place it on mine. Both Mr. Champion and Mr. Carnes appear as well. Is there a resolution in this case, gentlemen?
Yes, Your Honor, it's my understanding that defendant will plead guilty to an added count of attempted retail fraud second, and the people will dismiss the retail fraud second.
Mr. Champion?
And that's my understanding of the plea agreement, Your Honor.
Ms. Emery, have you heard what counsel has said today?
Yes, sir.
And is that your understanding of the plea agreement that's been reached?
Yes, Your Honor.
Will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Ms. Emery, I don't have a signed advice of rights form in my file, so I'm going to go through your rights with you, okay?
Yes, Your Honor.
If you require special accommodations to use the court because of disabilities, or if you require a foreign language interpreter to fully participate in the court proceedings, please contact the court immediately to make those arrangements. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You have the right to have a trial by jury and to have the assistance of an attorney. You have the right to have an attorney appointed at public expense if you are indigent, which means without money, to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay a portion of the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court. To see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest, the rights that we just went through will be given up. You also have the right to be released on bond. If you're currently on probation or parole and a finding of guilt or a guilty plea is entered, that could result in a violation of your probation or parole. You can be sentenced to jail, fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. You have the right to an appeal to the circuit court that may be taken within 21 days from the date of sentence or as permitted pursuant to court rule. If the sentence includes incarceration and you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after the date of sentencing. Federal and/or state law may prohibit you from possessing or owning firearms depending on the type of conviction that's entered. Do you understand those rights?
Yes, Your Honor, I do.
Do you understand that by entering a plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, sir, I do.
It's my understanding that the plea agreement in this case will be to an added count 2 of an attempted retail fraud second degree. That is a 6-month misdemeanor and/or a fine of $1,000 or 3 times the value of the property taken. In exchange for that plea, it's my understanding the prosecution will dismiss count number 1, retail fraud second degree, which is a 1-year misdemeanor and/or a fine of $2,000 or 3 times the amount taken. It's also my understanding that is how you wish to resolve the case.
Yes, sir.
And it's your own free choice to plead, correct?
Yes, Your Honor, sorry.
In order to, then to the added count 2, that you did attempt a retail fraud second degree on or about September 28th, 2024 in Herring Township in Wexford County, Michigan. How do you plead?
Guilty, Your Honor.
In order to accept your plea, I must have you tell me what it is that you did that makes you guilty. So what happened back on September 28th?
I went through a self-checkout at Myers, and my card wouldn't pay for some of the items that I had in my purse, so put them in there and tried to walk out.
And you would agree that that was in Herring Township here in Wexford County, Michigan?
Yes, sir.
And the value of the items that attempted to be taken had a value of $200 or more?
Correct, sir.
Do you counsel believe that the defendants provided a factual basis and that the court's been compliant with court rules?
Yes, Your Honor.
Yes, Your Honor, for the underlying charge.
As does the court, I find the plea is voluntary, knowing, and accurate. Ma'am, you've been found guilty of an attempted retail fraud second degree. Any allocution, Mr. Champion?
Yes, Your Honor, so the court's aware and can see that my client has been receiving treatment since last month. She's doing extremely well. She's accepting responsibility for her actions. It's anticipated she'll be in treatment for at least another 15 days. She's been in for 30 days up to this point. So with that, I would ask the court to consider just fines and costs. There's no restitution, all items.
Mr. Carnes?
Thank you, Your Honor. I had originally planned on asking for a jail sentence here, considering the 07 retail fraud third conviction and 22 convictions for retail fraud second possession. Given that defendant is in treatment, I'd ask the court for 90 days suspended sentence and a term of probation long enough to verify that she completes her inpatient treatment and any follow-up.
What type of items were taken or attempted to be taken?
Curtain rod hooks, travel bug strap cover, row 1 hand locking tongue, dog treat, dog treats. Looks like several dog treats.
Well, right there, you see, it was necessities, complete and total necessities. Let her go.
And the 3-in-1 dash window then.
Household items and dog treats. What was the value?
It was $200.86. I charged this as is. I didn't enhance to a retail product first, just 8 cents. Be more fair to just charge it as the second.
Anything else?
No, Your Honor.
Ms. Emery, is there anything you'd like me to know before sentencing?
No, Your Honor.
How's treatment going for you?
I'm working on it, and I'm gonna have to continue to work on it, but I feel like I'm doing really good.
Do you have any concerns about after?
Staying busy and staying in my recovery with my meetings and my sponsor.
And where do you plan to come back to the area after treatment's over with, or what are your plans?
I'm going back home to my husband and my children, but
Okay.
my meetings, and I have some meetings there in Cadillac.
Okay. Do you already have those meetings set up or have access to them?
I do from before, so.
You do from what, I'm sorry?
I do from before.
Okay.
When completion day comes, I will have more detailed.
Have you been in treatment before?
Back in 2023.
Okay.
Your Honor, may I add something for her?
Yes. Could you just state your name for the record, please?
Yes, I'm Roosevelt Bell, therapist at 1016 here in Midland, Michigan. I'm Cheyenne's therapist. Just wanted to add it that once she's completed, she's also going to be set up for outpatient therapy, where she'll continue to go, and that's probably going to be once or twice a week. She'll also be scheduled for AA, NA meetings and she'll be required to also obtain a sponsor.
Okay. Ms. Emery, if I'll be honest, I'm toying, excuse me, I'm toying with the idea of putting you on probation kind of as an incentive to help you follow through with your recovery and your aftercare. What are your thoughts on that?
Whatever you feel like you need to give me, I will take it. I do have another charge in Osceola County right now that I will have to be sentenced on the 28th, and I know I'm gonna get probation too,
What's that charge?
for methamphetamine.
Have you entered a plea in that case already?
Yes, well, we did the plea and I'm just
Okay.
doing sentencings on the 28th.
Okay. Okay, anything else?
No, Your Honor, that's it.
All right. There'll be a $75 crime victims' rights fee, a $50 state minimum fee, a fine of, we'll do $200, $200 court costs. Mr. Champion, attorney fees,
Leave it to discretion.
$150 attorney fee. Ms. Emery, I am going to put you on probation for a period of 12 months.
Okay,
You are eligible, though, for early release. So if you're successful with the terms of your probation at halftime, you can be released from probation. Because you are eligible for halftime release, I'm only going to charge you for 6 months of probation. But if you stay on longer than the 6 months, you'll be required to pay for that. Do you understand that?
yes, sir, Your Honor, I do.
Okay, so that is, it's $30 a month. So for the first 6 months, it's $180. Mr. Carnes, is it true there is no restitution requested?
That is correct, Your Honor. All items were recovered.
Does she have any jail?
She did have a bond, but I don't know when she went to credit. We don't get those from community corrections, so I don't know what credit she does have.
Ms. Emery, did you serve any jail on this case?
I was in, actually, when I got the warrant from Wexford County, I was already sitting in jail in Osceola County,
When did you go to 1016?
February 26th. I
So it
believe-
looks like you were arraigned on this case on February 20th. And then you said you were released the 26th?
Correct, sir.
So I believe that's 5 days credit.
Yeah.
There'll be 5 days jail with 5 days credit. By my calculations, there's an $855 fines and costs that we just went through. I must tell you that if you're more than 56 days, if there's a balance that remains after 56 days, there is a 20% penalty added. Do you understand that?
Yes, sir, I do.
Okay. Now, for your terms of probation, you are not to violate any law. You're to report as ordered, not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. I'm going to order that you not use any illegal controlled substances. That includes recreational marijuana. You'll be subject to testing pursuant to your probation officer. Any counseling is recommended by your probation officer, and any additional programming at their discretion. I'm also going to order that you not use any alcohol, that you not have any alcohol or legal controlled substances at your residence. Mr. Carnes, anything else?
No, Your Honor, thank you.
Mr. Champion?
Nothing further, Your Honor. Thank you.
Ms. Emery, any questions?
Yes, actually, I do. One more question. I was gonna see about, can I just get everything transferred to Osceola County?
Once you get set up with our probation department and you get sentenced in Osceola County, talk to our probation officer and see what can happen, okay?
Okay, thank you.
Okay, good luck.
Thank you.
Are we concluded, Your Honor?
Yes, you're free to leave. Okay, court next calls the people of the city of Cadillac versus Thomas Wayne Spencer, case number 25659OM. Appearances, please.
I'm Jeff Harrison. I'm going to be having Mr. Spencer.
And we're here for a pre-trial today? What are we doing?
My understanding, the defendant will plead guilty as charged.
That comports with my understanding as well.
Is it jail?
Hold on, I think we've lost the jail. Okay, we are back. on the case of City of Cadillac versus Thomas Wayne Spencer, case number 25659OM. Mr. Spencer, I'm not sure at what point we lost you, but council made their appearances and it indicated that this was going to be a plea as charged. Is that your understanding?
Yes, Your Honor.
I have a signed advice of rights form in my file, talked about your rights to an attorney and your rights to a trial. Did you read and sign that form?
Yes, I did, Your Honor.
Do you have any questions for me about those rights?
No, I don't, Your Honor.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, I do, Your Honor.
Will you please raise your right hand the best you can? Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Go ahead and put your hand down. Has anybody promised you anything in order to get you to plea?
No, Your Honor.
Has anybody threatened you in any way in order to get you to plea?
No, Your Honor.
And is it your own free choice to enter a plea today?
Yes, it is, Your Honor.
Then to the charge in count number 1 that on March 4th, 2025, here in the city of Cadillac in Wexford County, Michigan, you were a disorderly person. How do you plead?
Guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that you did that makes you a disorderly person. So what happened back on March 4th?
I was at the hospital and trying to get a heart loop monitor put in because I have AFib and my heart stops and I pass out, bust my face. With no warning, I don't know I'm going to go out because my heart's stopping is how U of M figured it out. It's been 2 years. They've been trying to find out why I was passing out. And police busted me in the face with a billy club and I got 34 stitches a year ago. And then while they stitched me up, they sent me to U of M and they figured out it was my heart. They said, your heart's stopping.
Okay,
and if you don't,
okay, but what makes you a disorderly person here in Cadillac back on March 4th?
The doctor that's at the hospital put me outside. He wouldn't admit me and he put me out at 17 below zero wind chill with just a blanket and a cup of coffee. And he was arguing the fact that I wasn't supposed to get this heart loop put in. So I started yelling at him and that was my disturbing the peace.
Well, whatever device he needs implanted into his heart, be it a pacemaker or whatever else, going to the emergency room and demanding they do immediate surgery to implant such a device, probably not the best plan. Not thought through at all on that one.
And when you were yelling at him, was that inside or outside of the hospital?
Inside.
And would you agree that that would cause a disturbance to others inside the hospital?
Yes, I do, Your Honor.
Do you counsel believe that the defendant has given a factual basis and that the court's been compliant with court rules?
I do. I do as well.
As does the court. Mr. Spencer, I find you guilty of disorderly person, penalty of the 90 days in jail and or a fine of not more than $500. Mr. Harrison, any allocution?
Well, Your Honor, he and I discussed it to some length. We believe that the events of the evening clearly show he was a person having some type of mental health issue or event anyway. Does not excuse his conduct. He is aware of that. He understands that he caused a disturbance in the hospital and broke the law. He has been incarcerated for a great, well,
I show 22 days.
22 days. Okay, I thought it was more for some reason. I apologize, I got sidetracked. He's been incarcerated for 22 days. He is aware of the fact that he needs to keep addressing his mental health, and he's going to do that. He's got stuff set up to take care of that when he gets out of jail. This is one of those situations where he believes if whatever cycle he was on that night hadn't been interrupted by, unfortunately, this event, it wouldn't have ended well. So in a way, this was a good thing that happened because it forced him to slow down and take advantage of services and resources that are available in the community. He's 63 years old. He's aware that his primary obligation to himself as well as to the community is to take care of his mental health, and he's got a plan to do that. I don't see the point in supervising him, nor do I see the point in any further incarceration pursuant to this matter. Thank you.
So Harrison, you mentioned something along the cycle that he was on. What do you mean by that?
I just mean whatever had happened that night that caused him to have some distress in his mental health, to behave what he termed to be, and he used the word irrationally, in response to a disagreement with the doctor. He knows now that you don't go to the emergency room and demand this kind of service, that there's sort of a chain of command that has to be followed. He, for some reason that evening, was unable to do that. So he's glad that that thought process got interrupted by this event. I mean, he's not happy about being in jail, being taken off his meds and all that kind of stuff, but this was a way that operated to bring about a positive result, at least for the future.
Okay. Ms. Carey?
Thank you. He was causing quite a disturbance at the hospital. He was aggressive towards staff. He locked himself in the bathroom. He was lucky he wasn't charged with R&L. He was continued to be aggressive with police. He possessed them. He had in his possession toilet paper that had been burnt and soaked in alcohol, whatever alcohol he had in the hospital.
Well, I've been
He has a history, a lengthy history, and it looks like he has a bench warrant out of Kalamazoo for an incident in January. The bench warrant looks like it was issued on February 13th for retail fraud third for failing to appear in Kalamazoo. So I would ask the court to take that into consideration. Thank you.
All right. So there'll be a $75 crime victims' rights fee, a $50 state minimum fee, a fine of $150, court costs of $150. Attorney fee, Mr. Harrison?
My involvement just today, he doesn't have any money.
Is that a waiver of attorney fee?
Yeah.
Mr. Spencer, is there anything you'd like me to know before sentencing?
No, Your Honor.
Well, Mr. Harrison has said that you've learned certain things from this episode. Is that true?
Yes, Your Honor, I have.
Have you been getting the necessary help that you need while you've been in jail these past 22 days?
Yes, Your Honor. I've been on, for 30 years, I've been getting mental health. That's why he set me out 22 days, because he said that I was a danger to the community, and they turned down my PR bond 22 days ago. I was honest with him. I said I got molested as a little boy, and I've been on my meds for 30 years. And he said, oh, you're a danger to the community. So he set me out 22 days to court.
Well, I was the judge who did that arraignment, and I remember your arraignment, and there you seem to be doing better today than you were back then.
Oh, absolutely.
So, what are your plans if you're released from jail? What do you plan?
I'm going to rehab in Florida. The police in Kalamazoo, this warrant, the state police had me in the car the other day, the day that I came in here, the same day. And the Kalamazoo said, get them handcuffs off him and let him out of the car. The reason I have a warrant is because I was up here. I can't be in here in Kalamazoo at the same time. So I'm going back to Kalamazoo. The police are sending me back down there on Indian trails. I'm going to take care of that warrant, and then they're sending me to Florida to a rehab in Gainesville, Florida.
In Gainesville?
Yeah.
Okay. Is there anything else you'd like me to know?
No, that's it, Your Honor.
Well, there'll be a $75 crime victims' rights fee, a $50 state minimum fee, a fine of $150, court costs of $150. Attorney fee, Mr. Harrison?
My involvement just today, he doesn't have any money.
Is that a waiver of attorney fee?
Yeah.
I'm not going to order probation, Mr. Spencer. I'm going to trust that you're going to continue to get the help that you need, okay?
Yes, I will, Your Honor.
I'll order 22 days jail with 22 days credit. That means you get released today, once your paperwork's been processed. You understand that?
Yes, sir. I can pay this fine as soon as I cash a check. The state police has a $4,000 arrearage for Social Security that got stolen from me, and it should be at the state
Okay.
police post. If not, it'll be here in a week if they reissue another check, so I'll pay this off there within a week.
Okay, well, I show that's $425. So just as soon as you're able to make a payment on that, if you have any balance, it's more than 56 days late, there's a 20% penalty. Do you understand that?
I'll pay it in full, Your Honor, this week. As soon as I get the check.
All
it'll
right.
be paid in.
Counsel, anything else?
Nothing further, Your Honor.
All right. Thank you, Mr. Spencer. Good luck to you.
Thank you. Have a great day.
You too.
People are making?
Yes, Your Honor. Defendant enters a plea to count 2. We will dismiss the balance of the charges. We have sentencing guidelines at 0 to 11 months. We will cap an incarceration in the county jail at 90 days.
Mr. Prysock, is that your understanding of the offer?
It is, Judge. If I could just have 1 second with Mr. Massey.
I'd like to say something, Judge.
You need to talk to me. Okay. You're going to go to trial.
Yes, that's my only option. It's not an option, I'm not good to.
Okay. All right. Judge, at this point in time, Mr. Massey rejects the offer.
Okay.
And I think he wants to address the court for some reason. It's fine with me.
All right, Mr. Maslick, is there something that you think the court should know?
Yes, I'd like my attorney to hand you this.
What is it? Mr. Maslick, what is it?
It's a motion to represent myself.
Okay.
All right, so it looks like you can take a look at it, Judge. It looks like
Yeah, this one needs help in the form of a lawyer that he just requested withdraw.
motion to remove me from the case. And then it's a motion to dismiss. And looks like a petition for a same-day sentencing, so.
Okay, fine. So, all right, so Mr. Maslick, why do you no longer want the services of Mr. Prysock?
Well, he didn't inform me that my case number was changed on my file, and
Yeah.
I just got.
So, the case numbers, when they start out in district court, they get a certain district court number, and then when they come to the circuit court, they get a circuit court number. That happens in every case. That's on the paper.
Okay, well, also, I find this whole ordeal a conflict of interest, and that's never been addressed, and I've addressed it every time.
So what's the conflict of interest?
So my cousins are Paul and Matthew Jones.
Okay.
So Mr. Prysock here represented them.
Okay.
So I'd like to represent myself, so I can file my own motion, sir.
Well, the fact that Mr. Prysock represented one of your cousins 10 years ago, 9 years ago, doesn't have any impact on this case.
Okay, and then there was also some miscellaneous actions done in my report, and there's 70 incidents on my miscellaneous actions by clerk, refer to administrative actions. Okay.
All right.
Right.
That's fine. That doesn't sound like anything that has to do with Mr.
The lead
Prysock.
witness.
Stop.
Can I say one more?
No, stop. So that stuff doesn't have anything to do with Mr. Prysock. But the person does have the constitutional right to represent themselves. Okay? Court has to find that you have made a knowing and voluntary waiver of your right to counsel. So you do understand that you have the right to hire somebody if you want? You understand that?
Yes, sir.
Do you understand that you have the right to have the court appoint an attorney to represent you if you could not afford an attorney? And that's why you've got Mr. Price on. You understand that?
Yes, sir.
You understand that there's risks associated with representing yourself?
Yes, sir.
Like you may not know the rules of criminal procedure, you may not know the rules of evidence, you may not know how to effectively cross-examine witnesses, you may not know the process to have the court issue subpoenas for anybody to testify on their own behalf, you may not know how to secure any expert witnesses that you may need. Looks like there's a charge of possession of amphetamine. You may not have the technical knowledge to cross-examine the question any state laboratory person that they would call in to know about the procedures that they have to follow to certify their equipment. I mean, there's a lot to representing yourself that you may not know. Do you understand the risks there?
Yes, sir.
Okay. And bearing those risks in mind, do you still want to be your own attorney?
Yes, sir.
Okay. You've heard the saying that a person who represents themselves as a fool for a client. You've heard that before, right?
Yes, sir.
Okay. There's been several people that have represented themselves in circuit court. None of them have ever been found not guilty after a trial.
There you go.
You understand that?
Yes, sir.
Okay.
None of them? That's a shocking statistic.
So bearing all those things in mind, you want to represent yourself.
Yes, sir.
Okay. All right, so the court does find that you made a knowing and voluntary waiver of the right to be represented by an attorney. We'll set this case for trial. You've been in jail most recently since the first part of February, is that right?
Yes, sir.
Okay. Set you for trial August 19, 20, 21, and 22.
I have some motions for you, Your Honor.
Well, hang on. That's one of those things where if you had an attorney, they would know the process to do that. So to file a motion, you have to file it with the court clerk. You have to get a copy to the prosecutor. And you have to get a hearing date. So it's not something that you can just throw it on the prosecutor's desk or my desk and say, let's do that today. It's not the way it works. They have the time to prepare and research the law and get any witnesses that they may need to help them in the case. So if you want to file that, you can submit it just like any other attorney or self-represented person could do to the circuit court. You need to have a copy for the prosecutor, and then we'll notice it up for a hearing. Okay? It's complicated. You'd be much better off with an attorney. But it is your right to not. All right, that's all for today.
Just for the record, I have given Mr. Nassar copy of the police report, the indictment, and his preliminary transcript. I will go through my file, make sure that, I think there's still some things in there I was going to get to him.
Good morning, Francesca. Francesca?
Sorry, Judge, I had my
Can you hear
volume
me?
off. I never turned it back on.
Oh,
My
all right.
apologies.
No
Judge,
problem.
the court can call Stacy Schropp versus Great Expressions Dental Centers. Time and date set for emergency motion.
Appearances?
Good morning, Your Honor. This is Eric Berlin for the plaintiff.
Good morning, Your Honor. Zach Lincoln for the defendants.
So let me ask a question before we get started. Has the facilitation with Judge Groner already been adjourned?
No, Your Honor, it has not. And it's my this is Eric Berlin for the plaintiff. It's my understanding that we have proposed adjourning that facilitation with a new date with Judge Groner, but that Mr. Lincoln's office and their client were not amenable to that suggestion. So still want to go forward with the Monday facilitation.
Well, why not if the exercise of the last month or two has been to get the expert step before the facilitation? You go ahead, Mr. Lincoln. I read your motion, by the way, Mr. Berlin.
Thank you, Your Honor.
Sure. What was the question, Your Honor, specifically about?
Why don't you want to adjourn the facilitation?
I don't, speaking kind of off the record here, I don't personally have a problem with moving the facilitation. It's just the proposed date that Mr. Berlin has given me for the next time that he's available, which is the 4th. We're not available for that date. So that if we, we can't take that date, so we can't take the dep before whatever this alternative 8th or 9th date is with Groner. So unfortunately, it kind of complicates things because we have a settlement conference with you again on the 16th.
So why couldn't the two of you work out the simple matter of picking new dates rather than imposing on the court to have to read an emergency motion and then to hear it in the middle of all my settlement conferences?
Your Honor,
Right, Your Honor.
Go ahead, Zach. That's okay. Go ahead.
The position of my client has been, we've been trying to seek this deposition since at least October of 2024. It ultimately culminated in the motion to compel, compelling his deposition to be taking place within 30 days. That deadline had passed. We offered another extension. And so we're just on to another extension beyond that. There's already a court order entered by you from that motion to compel that Dr. Wattsman would be precluded from testifying at trial if he wasn't deposed by X date, which happens to be March 12th. So the position of my
hold
client.
on, let me interrupt you, Mr. Berlin. What's been the problem getting a date for your expert's deposition? And we started this when, back in January, February?
Yeah, Your Honor. So by way of background, there hasn't really been a problem. The date was provided. And as I know Your Honor has read the motion.
Yeah, he canceled it though, right? The date.
Correct. Yes, he just and that was at, I think, the Monday before the Wednesday scheduled deposition. So I candidly, Your Honor, can't speak to what was going on before I got involved with the case with regard to the expert deposition.
So they're
request,
they're not available on the date you and your expert arbitrarily picked after you canceled the date that it was supposed to go forward. So you two work out a new date for the deposition, then work out a new date with Judge Groner for the facilitation, and then notify. Well, I'll just give you a new settlement conference date. What date did we have for the 16th?
Yes, Your Honor.
For settlement conference?
Yes, Your Honor.
Do I remember? All right. So hold on. What's that case number, Francesca?
It is 234150 NH.
All right.
Case was open 12/5 of 23.
Let's go to May. What's our May 2nd look like? Or Francesca, you give me a date, end of April or first 2 weeks in May. That's our lightest day.
So I can do April 23rd or May 7th.
Gentlemen, what's your preference?
Your Honor, I think to be safe, May 7th, just to make sure that this can be accomplished and we don't have to.
All right. All right. And so we'll set a new settlement conference May 7th. Submit an order saying that both the April 4th deposition of the expert, the March 31st deposition, facilitation with Judge Groner is adjourned. Both are to be conducted in the month of April, and the deposition is to precede the facilitation.
Yes, Your Honor.
And you guys work out dates.
Thank you, Your Honor.
Thank
You're
you. What
welcome.
time on the 7th?
9:30 a.m. via phone conference.
It's over phone? Okay.
Yeah.
Thank you.
Appreciate it. Thank you, Judge.
Thank you,
You're
Judge. I
welcome.
appreciate you hearing this on an emergency basis. Have a good weekend, everybody.
Okay, you're welcome. Bye.
Thanks, Your Honor.
Guys,
Bye,
bye.
Zach. Bye.
The judge is so annoyed that scheduling a simple hearing had to be heard as an emergency. This is not the judge to do that with. No. This is a, you want to talk about a grumpy judge. This is the grump of all grumps of judges. And apparently, I messed up my editing. Because that was the last case. And it shows that I still have more. But I don't. I'll have to figure out what I did when I edited. It's probably like the watermark or something. I don't even know. But yeah. Thank you. I had fun tonight. Oh, I bet they do. Yeah. I don't like playing games with judges. I don't think that's a good idea. I don't think I'll win. All right, guys. Thank you so much for coming out and hanging out with me. I'm gonna go cuddle with my sweet, sweet baby. Look at her. She looks like she needs lovin's. Poor girl. The vet said that everything went fine. Ava was perfect. They trimmed her nails. They microchipped her. They spayed her. She got a 2-year. I want to say it was distemper or something, but I know that's what cats get. I don't know if dogs get it. They did a lot of stuff. They did a heartworm test. It came back negative. Oh, she is 69 pounds and they want her to be 56. So, it's proof to you guys that she is spoiled. Yep. Absolutely. Ooh. The Discord. Home of Farkle. I actually she was getting Purina the last bag. The Blue Buffalo was sent by Joey Bag of Donuts, and I couldn't afford to get a replacement Blue Buffalo when that one emptied. So she went back to Purina. She ate half the bag and then decided she's never touching it again, ever. And the food literally sat in the bowl for over a week. And before I was like, yeah, I need to do something about this. The vet said it's normal that if you leave the bag open, it kind of gives a spoilage smell to the dogs, and they don't like it, so they don't eat it. So I have to just buy new food. It gets delivered in the morning. And yes, I did go back to Blue Buffalo. I'm just doing smaller bags at a time. You know. It feels that way. It really does. It really does. Here's that Discord link. All right, guys. Thanks again for coming out. Be safe, be well, sleep sweet, and much love.